All right, good afternoon, ladies and gentlemen. I have a quorum now, and we're going to get ready to get started. If I could call on Vice Chair, if you would, open us up.
Let us pray. Dear Lord, we thank you that spring is springing outdoors here in Georgia. We thank you for this time together. We pray that you will give us wisdom, justice, and moderation on this important people's business before us today. In your name we pray, amen.
Amen. Thank you. All right. First bill I want to call up is Senate Bill 508. Afternoon. When you get settled, you have the floor.
Thank you very much. Thank you for allowing me to bring Senate Bill 508 before you. What it does is it adds to the duties of the Administrative Office of the Courts, and it simply establishes and maintains a database to conceal and protect personal and important information of justices, state and local judges and their spouses. So it would allow them to conceal their address, their phone numbers, things like that, to protect them. And this bill is personally important to me. We ran a swatting bill recently that Representative Reeves carried on my behalf on the House side, and this is designed to protect these folks as well, because it can be a very dangerous thing, and the decisions and situations that they're put in, the threats that they get, are much more magnified than what we get as legislators. But be happy to answer any questions, Mr. Chairman.
Who's got Representative Silcox? No? You wave? All right. All right. Are there any other speakers on this bill?
We're for it, Mr. Chairman.
Thank you. I do have one question, and this is just from my personal experience. When I came off the bench, my name and address and all that was kept quiet. Then I get a notice that it's going to be made public. And there are still people out there that probably don't like some of the decisions I made. Is there any way your bill deals with this for somebody that's retired?
You know, that's a great question. Would be happy to add that to it because, you know, retired judges' decisions y'all have had to make, you know, in the past would lend yourselves to potentially
some people don't forget.
Threats and danger. Yeah.
All right.
May I volunteer one thing on that point?
Yes, sir. Please have a seat.
The critical thing this bill does is it creates a mechanism by which who is a judge gets told to the agencies that have the judge's information. The effective date isn't until next year, because that process is going to take time to develop. And so we can definitely come back next year and tweak that once the process is further down the road, if that would be helpful.
That would be very helpful. Thank you. Appreciate that. Representative Silcox.
Thank you, Mr. Chairman. I was just going to say, could we just add simply at line 34, between 34 and 35, just add to protected person to mean any retired judge?
Representative Reeves.
I support that. I had also seen on lines 59 and 65 where it says judge or justice, maybe add present, former, or senior there in addition to, I like Representative Silcox's amendment.
Representative Evans.
Thank you, Mr. Chairman. A suggestion that would take both of those and potentially be simpler, though someone will tell me if I'm wrong. On line 30, protected person means any current or former, and then you've got ABC, and then you don't have to worry about it anywhere else, I think.
All right.
That would be a friendly addition.
Okay. You said that was on line 30,
Yes, Mr. Chairman.
and that is inserted where?
It would be on line 30 after the word any, insert current or former.
How about with your amendment? Does that encompass it?
Let's get. That seems the simplest, and as Justice Peterson pointed out, we can come back and add more next year if needed. So I think that's a good start on that.
All right. Go ahead.
Make a motion to pass.
Do I hear a second?
Second.
I have a motion and a second. Any further discussion? We have an amendment, as we discussed earlier, to line 30, adding after the word any current or former. Any questions about that? Any further discussion? All those in favor of the amendment, say aye.
Aye.
Any opposed? All right, we have that amendment on there. Any further discussion about the bill? Hearing none, all those in favor say aye.
Aye.
Any opposed? Okay, your bill's passed.
Thank you, Mr. Chairman. Can I leave this with you?
Yes, sir.
Representative Reeves is kind enough to carry this bill.
Oh, okay, thank you. I can give this right back to you.
Thank you.
There you go. All right. All right, Chairman Tillery, come on up.
I'm back, Mr. Chairman. I wasn't going to go away.
Always welcome, always welcome.
I don't know which one you want first.
Your choice. Which one you want to tackle first?
I'd rather tackle the notary one first, honestly.
All right, let's do that.
Sorry.
No, no worries.
425.
I'm here cheerleading for you.
This is the support of the department for the notary bill. Is that right? Just want to make sure we know
Whatever
that.
it takes.
Make sure we know that for the next one. Senate Bill 425. Mr. Chairman, I'm probably not the one anyone thought would ever champion a notary bill, an e-notary bill. I've spent 4 years beating it, trying to hold it back, concerned for what it did for not so much really our practice of law, but was really concerned for what it would do in a banking situation. My concern was that if we allowed e-notary without some restrictions to kind of place around it and some guardrails to make sure it didn't get off the rails really fast, that what we would end up with is a bunch of closings that are centralized in lower Manhattan to the detriment really of our community banks. And our community banks will become storefronts to others that then no longer were needed as storefronts as e-commerce continued to trend. And I don't know what you've seen in your areas, but I've already watched more than one bank in my area over the past 20 years fail. I made a joke one time that the tax commissioner already had an office. I didn't need another closed bank. I don't know if that's what happens in your neck of the woods, but the tax commissioner buys it, uses the teller tubes to collect the payments, and then that's what the old bank becomes. We don't need that anymore in the 11 counties that I represent. So why this year have I changed my tune a little bit? Am I back up Blake, as my good friend Senator Brass has called me? No. We have, thank you, at least not till next week. I know how that goes. No, it's a realization that the technology was going to catch us anyway. And all I wanted to do for 2 to 3, 4 years is to slow down and allow our banks and our other entities to get caught up and be ready for when this hit. Clearly, COVID accelerated it. And now we're at a point that I think we can go ahead and move forward, like 45 states have already, with some type of e-closing and e-notary bill, and not end up eviscerating our community banks. So what 425 does is tries to walk the line and bridge that in a way to be effective and move Georgia into the 21st century while not allowing us to just fall apart. If you look at lines, let's start here. I think it's also important to tell you that there have been probably 15 versions of this. There have been it started off that all closings were included, and then we had some requests that we carve out different parts. We carved out commercial, then there were some requests we carve out some other things, and then there's some requests even after we came out of the Senate committee that we make some changes again. And I won't walk you through all of them, but I'll tell you what it basically says is this. This bill codifies the Supreme Court's decisions as to what's the practice of law. And it then says if you're going to practice the law and it's going to involve closing of real estate closings, then you're going to have to follow the Supreme Court rules that have sort of gone around that already. We then take and pull commercial real estate out and say commercial is going to be defined separately. The battle you may hear later on is what happens with those houses, residential houses, not commercial again, that are 1 to 4 residences. Well, the argument from residential attorneys is going to be like, those are still residential. The argument from some commercials are, hey, no, they're blocked together, sold in bulk, kind of what I was concerned of happening already, remember, and they are commercial. This bill, and I take the side that they should be residential for reasons I think that'll make sense later. It then says if you want to do an in-person notary, you still can do it. It doesn't try to do away with that. It does make clear what's been expected and laid out in state bar opinions already, that you can't do a witness-only closing. If you're going to do a closing, you're supposed to supervise the acts of the closing. The bill later on takes and says if you want to use an e-notary for anything besides real estate and wills, that's cool. That's not a problem. Wills and estates, I'm kind of grouping it all together. They were excluded in every single version I've ever seen, including Representative Gullett's original version. Wills were excluded. They're excluded again here. And then says if you do, though, want to do a closing e-notary-wise or e-closing-wise, then you have to follow Georgia statutes to do it. And what those say is you have to use a Georgia attorney to do it. The Georgia attorney needs to be in Georgia to do it. If you're going to have a witness, the witness has to be able to see, record, keep up with all the things that you would think that are necessary for that. And you can only do one closing at a time. I mean, it seems novel to think that if you're supervising it, you can only do one at a time. But again, we're trying to push back against the consolidation and conglomeration to just centralize all these things in Lower Manhattan. If you were to violate that, though, there's a pretty stiff penalty, and you'll hear some folks are opposed to that. You could potentially get hit with a fine of up to $20,000 for violation. We want it to be stiff because we think it matters that you have some nexus to Georgia if you're doing a Georgia residential closing. Doing a commercial closing, we're trying to leave you out of this one. And then there's some folks who say, well, only the Attorney General should be able to bring it, or only the state bar should bring it, or only bar associations should bring it. I don't think that's the case. You see, the Attorney General's busy. The state bar sometimes does things. And so we need to leave this open for other attorneys to make those moves if that were to happen and they're able to see this grievance. So this allows individual attorneys as well as others to bring the action. The rest of the bill, I'm sure you've had some chances to go over. I want to walk you through one of the changes that was made since, again, we tried to be as conciliatory as possible to get to where we are now, including making amendments after it came out of the Senate. One of the big ones raised by some folks, I think there were commercial real estate closing attorneys, was they were concerned that the version as passed from the Senate would allow a potential finding that the e-notary was done or the e-closing was done inappropriately to void the deed. They were worried that that would create problems potentially with mortgages and obviously with secured transactions. And so we pulled that out. That is no longer in. So if you hear that brought up, so that again, just another concession to try to get to the closing. Or get this closing bill across the closing line. Some things you may anticipate you may hear in just a minute about conveyances. There's been some suggestions about we need to change the lines 35 and 36 as they relate to conveyances. But right now, any act that constitutes the practice of law, we've tried to keep that and reference that the Supreme Court has defined these interconnected activities of what make up a real estate closing already. So I don't think that argument that this somehow gets into unconstitutional grounds of defining the practice of law is a problem here. We've also heard that I already mentioned to you about the one to four provision, which I think is kind of now the controversial provision. But I want to remind you that we already carved out commercial from the first versions to try to assuage the concerns related to commercial entities. And in that instance, I would ask you to please keep the 1 to 4 real estate closings with needing an e-closing. I mentioned to you the provision that may come up about a private attorney being able to bring the action. I think that matters. If the law's being violated, who cares who's bringing it? And then there's another provision, I think, kind of towards the end that you may hear argued about. Well, back up, that some folks who have opposed the bill and it was mostly on the commercial side and asked to be carved out of this, now they want to be in the e-notary part. And I think that's evidence that this does move the ball forward. It does move us to a position that the state's not at now. And to allow any more of a carve-out would be more of a have your cake and eat it too model that I just don't think is the balance that this bill strikes. So thank you for hearing it today. Appreciate you giving me time to speak. And I can't believe I'm saying this, but I ask your favorable consideration of the state's e-notary and e-closing bill.
Okay, where's that? List. Oh, you got it. All right, I don't see any questions for you. Okay, I have a number of folks that want to speak on this.
You want me to leave the table?
Yeah, you're probably going to need to. Oh, hold on, let me see.
Mr. Chairman, once we hear all testimony, will we have an opportunity to ask the author, or would you rather ask all the questions now about the author?
Well, if you have any for him, now would be a good time while he's here.
Okay.
So.
Mr. Chairman, this is an interesting position I see myself in, because I was in the position you're in 2 years ago when we passed the bill, and you persuaded me to say no, we don't need to pass this bill. So now the roles are reversed, and so I've got questions about the bill, and one of the, if you don't mind, I'm going to just go through it from line, by line. I'm 35. We're saying conveyancing, and I know that we're adding some language in there to say, including transfers of ownership of real property. Is it your intent to just for ownership of real property? If we're talking about easements or licenses on property, do you think that we need to add that in there to assure that a lawyer does that is a practice of law, or was it just kind of mindful of what the bill does here?
All we were trying to do there is give homage to the Supreme Court decisions that have already defined what constitutes the practice of law. Mm-hmm. So I would argue that thank you for the catch. Yeah. I think, though, that the transfer of ownership is you're even owning an easement. It's just a different level of ownership.
Sure.
So I think we caught that, and thank you for that question. It does help highlight, though, that the portion of that portion of the bill is just to bring in the Supreme Court decisions already made.
Sure. Very good. And so I want to get to the can you walk me through the how we're going to perform the basically online closing portion? I think it starts at 73 and it walks through.
So right. So you got definitions that go before them.
All right.
You're going to start at 83, I think, actually.
Okay.
So any real estate closing using electronic means, you have the following duties. Walks through first what the attorney has to do. Get the consent of everybody. Utilize and then we're at 88, utilize two-way audio and video communication. Confirm the identity of the signatories. Ensure the two-way communication provides a recording that does the three things listed on 95, 96, and 97, and 99. The four things there. So I don't know, is that kind of what you're wanting me to
That's
walk
perfect.
through?
Perfect. And then G is retain possession of electronic documents and
For up to
copy
6
of
years.
audio visual recording.
Right.
How do envision us doing that. I think in our offline conversations we talked about having either a provider or having our own hard drive and
Server.
sort of keeping that together. Is that what your thoughts are?
Yeah, this is not a provider-based bill, but I do believe people will get into this.
Sure.
You know, we pass something, somebody's going to jump up and do it.
Yeah, I expect that too. And then on lines 93, 94, ensure the two-way radio video communication technology.
You did what I just did. Audio, video communication. Yeah, we did the same. Go ahead. I'm sorry.
Do you think there's any essentially is this going to increase the cost of a closing?
Great question. I know that right now I could do 1, 2, 3, and 4 and hold it on my server using just Zoom and Microsoft Teams. Now, will there be other providers that jump into the market? I'm sure.
Whatever makes it easier for the attorney is going to be what they go with. So I get what you're saying.
And that's what the attorney has to. You know, there's other provisions again for where the witness has to be, and then the provisions that start on line 113 talk about what the notary public has to do. Because remember, you still have to notarize a deed in Georgia.
And then the witness
Or
portion
conveyance.
on 2, Mr. Chairman. The witness actually has to be in the room. Is the way I read that. The witness actually has to be in the room, be in the same physical location as the signatory, which is or.
That's right. And then
So-
line 2 is the separator out that says that they can be where as long as they're in the video place too, they could sign.
So is it a possibility? I guess then what we're looking at is so actually someone could be sitting at their apartment on Zoom and the witness and the attorney could be in an office somewhere, and that's how the closing would occur. Is that right?
It could be. And note that the witness has to sign the document. The witness and sign the document. So
The witness actually wet-inks the document. Is that right? What's that? Okay, all electronic signatures. Very good. Thank you. All right. And then going on to, you can do one of these closings at a time. I appreciate you putting that in the bill. Does that mean that just means an attorney can do one at a time, but if you have a firm with multiple attorneys, each attorney at the firm could be doing as many as they want. I mean, at a time, one at a time. So if you have 5 attorneys, you could do 5 at a time.
you could.
Okay. Now, this is where I think you and I are both probably have some reservation. Do you see this as the ability for a large, volume-oriented real estate practice to be able to do a closing in Vidalia, Georgia, and or Waycross, Georgia?
I do.
Okay.
And thanks for that comment. I want to make this point though. I'm not worried about this bill putting lawyers out of business. And if it does, they'll move on to something else. That's not my concern here. My concern with this was that you were going to take banks and put banks in a situation where doing these repetitively over and over, that all of a sudden the community bank is no longer even able to get the origination fee, which goes many times then to sponsor the T-ball team. So that was more my concern than the attorney aspect of it.
Very good. Well, I agree with you. That's a primary concern of mine as well. But the point is not so much about the attorney in Atlanta doing a Vidalia closing. You and I both practice in the real estate area. When we go do a title search, we know where to look.
That's true.
We know what pitfalls to find. And for instance, in Waycross, if you have a lot in your chain of title, there's a book that's not even in the code that'll tell you what happened because there was a lot of arm's length transactions 1910, 1912 that muddied the waters of what the actual chain of title looks like. So from the get-go, for me, the nervousness about this is we've got a rise in fraudulent transactions taking place. I just had an attorney call me this weekend that said he got took for $250,000 that he had to pay back personally. His insurance didn't pay for, and it originates from the boldness of some folks that are representing themselves as sellers. I'm the seller of this property, actually hiring a realtor, and then holding themselves out as the seller, and doing a remote closing like we do now, not like a mail away closing, not remote in this nature. My nervousness is on two fronts. Is that we have that problem now, and extending this to a scenario where someone can sit in, insert any country and represent themselves as a seller and show a card that is a government issued ID. That's one of my primary concerns. Not opposed to the idea of the bill. Certainly not opposed to my friend bringing it. We've had many, many long conversations about this, and I appreciate you bringing the bill. But that concern, and then secondarily the title concern. If you've done a closing, and we've talked about this, where everything is being vertically integrated, which is great and efficient for the buyer, right? So you look at a house online, you apply for a loan online, you get your financing online, and that was the concern I had about taking this large purchase for the most part. Most people in America, the largest purchase is their house. Well, you're taking that away from sitting in the community bank. You're taking it away from sitting with the realtor in your local community, and then you're also taking away from the financing there locally. But the chain of title is the most precious thing, as far as I'm concerned, in the transaction. Because if the chain is muddied up and there's a dangling interest of some sort, then you can convey a piece of property and then you don't have fee simple title. So I've dealt with many of these remote sort of financiers, and we're trying to do a closing at 2 o'clock on Friday, and I call them at 1 o'clock. We don't have a packet yet. Where's the packet yet? I call them and talk to them, and they're like, "Oh man, I'm sorry. Kids are at the house. They're working from home." And they send this packet in, and we had packets delivered after closing time. So you've dealt with that, I've dealt with that, we've all dealt with that, are in this business. My fear is that this type of scenario, that type of diligence is going to be extended to the chain of title, where you and me are not doing the title search or perfecting the title, and you've got somebody looking at a chain of title on, let's say, their insurance. They have a tab there where you can run the title on the insurance, and then you don't have a perfected title, and they do a transfer. Somebody pays $250,000 for a house in South Georgia, and then they have a dangling interest out there. Those are my concerns, Mr. Chairman. Yeah. I want to put them on the record. I appreciate you bringing the bill. I think this is a step towards being more technology friendly, but I just have those reservations about the fact that these folks are going to be able to be these folks that are committing fraud are going to be emboldened, and then the chain of title perspective.
May I respond to that, Mr. Chairman?
You may.
Exactly. I don't think that I could have said it better, and which is the reason why for 4 years I've turned to you and said, "Listen, let's pause this, let's slow it down." I appreciate your help with that. One of the changes that we've made to this bill that did not appeared in some versions before, but at lines 270 through 280, you'll see that the notary public, it talks about the notary public and the two-way video again. I almost said radio again. But the signatory has to be physically located in the United States. But that seemed a little bit narrow to us too. So we said folks who are going to be using this also be military personnel or at the U.S. Embassy or at the consulate or the diplomatic mission to present evidence of his or her identity and location. Because what you said is a real problem. And I do fear, while I support this and am moving it forward, I do fear that what we will see is a rise in title insurance claims, because you knew where to go look. I know in Toombs County that I'm going to have to pull out this book that, I mean, who even knew we had homeowners associations in Toombs County? Most people don't. When you drive by them, you don't think you do. So if you're counting on that, you're not going to be able to see that you have to, what you said is exactly right. And that is why lines 270 through 280 are in there, is to help push back as much as we can while realizing, there's probably a federal bill coming. And if the federal bill says you've got to take this, we've got to accept this, then we're one of 5 states left who would be the Wild West.
Mr. Chairman, I want to tell you thank you for your leadership on this issue. Thank you for vetting this bill. Thank you for going, getting in depth and into the weeds with the bill. And I appreciate your work on this.
Representative Reeves.
Mr. Chairman, the electronic means provision in line 83 and following, did the governor's emergency order during COVID give us somewhat of a beta test of that? Is this somewhat similar to what closing lawyers did for a year or more during COVID?
I don't think we were required to record it at the time, but then that's helping, we hope, to push back against what we think may be a surge of title insurance crime.
And Zoom and other video conferencing that most lawyers have learned how to use, you can record on those, right?
You can.
And it goes to your email and you could save it to your file.
Yes, sir.
And then I learned yesterday how to give a commercial for bills in Senate Judiciary or Senate Finance. So House Bill 1292 in Senate Judiciary is a good bill to crack down on real estate fraud that the whip mentioned. That's one that we work with the clerks and a lot of other people who handle deeds to make sure that we don't have these fraudulent sellers gathering deeds fraudulently, particularly from senior citizens. So appreciate what you're doing here, and I think that bill over there in the Senate would dovetail nicely.
Thank you.
Representative Stoner.
Thank you, Mr. Chairman. Mr. Chairman, thank you for bringing this bill. As several folks on this committee know, I deal in real estate, but as a owner and buyer. I'm not a lawyer, even though I'm on this committee. But I will say, as someone who's done this in other states, because I do business around the country, I'm glad to see this bill. I understand all the concerns that have been raised. I don't, make those minor issues that should be concerned about. I will say, though, as I've operated in other states, it makes it easier that we now do this. I'm glad to see that finally we're going to try to do this in Georgia, but obviously with precautions, which I totally understand.
Well, I am a lawyer, and I'm not on Senate duty, so we can trade love.
Okay. So yeah, I'm glad to see this bill. I'm glad to see that we're going to finally kind of catch up with the rest of the country. Thank you, Mr. Chairman.
All right. That's all the questions. Well, hang on. Representative Silcox.
Thank you, Mr. Chairman. And I had a few questions, and I guess my first question is going back originally to line 35. If you say at line 30, the practice of law is defined as follows, it doesn't make sense to me to repeat on line 36 that constitutes the practice of law. To me, those seem to be in conflict.
Our thought was that would be helpful to, in one of the amendments to some of the concessions we were trying to make. So, in other words, not saying that it would involve all real estate closings, but we were actually trying to use that to narrow slightly so we didn't grab something outside of Supreme Court opinion on accident.
Okay. And then my next question would be on line 76. If you go to be licensed and present in this state at the time of such closing. There are many, many commercial transactions that do not occur in the state, and so it would be impossible for people to be present in the state always, correct?
Thank you. So that's why you need to go back to the definition of real estate closing on lines 57 through 61, because you're absolutely right. So if there were things mainly in the ones that are happening outside the state are mainly in a commercial setting. So if that's the case, they don't fall under our e-closing provision at all.
And so then my next question would be, would you entertain a different definition for real estate closing?
I'd be happy to hear it. It will affect the entire bill, though, and if that definition was to pull out 1 to 4, I would ask the committee to please be cautious about going there.
Okay. So we'll move along then with these other questions. My next question would be on line 160, and that is the Attorney General, any district attorney, State Bar of Georgia, Judicial Council of the state, any attorney. To me, that seems to be in conflict. Like the attorneys could report on each other, could rat out each other.
Yes, ma'am. I think that's exactly what we want.
It is.
Yes, ma'am.
Okay.
So if someone's taking and millhousing closings, what you want is the other attorneys to have a reason to say, hey, these guys are violating Georgia law. If we're going to rely on the Attorney General, I mean, that's only one man or woman, I would suggest that there's no chance they're ever going to figure all of that out.
Okay. And then finally, let's see, at line 296, I believe you go to the definition there of notarial acts. Would you entertain a different definition there of notarial acts?
Help me out with that definition. What 296 in my version right now refers to the code section. Is that the code section we use to provide? Let's see here. Let me go up a little bit. A notary public may uses an electronic signature.
Let me just make sure, because we've got different. Right. Because I would like to add to that, notwithstanding subsection 5 of Code Section 4517.9, notarial acts as well as attestation by an unofficial witness may be performed remotely in connection with commercial real estate transactions, but not for real estate closings.
Okay. On lines 287 through 289, I think it's present already.
Okay. Let me just be sure. Okay. All right. Thank you. Thank you for that.
No, thank you for bringing it up. I'm glad you made a catch to make sure we put it there.
And I guess my last thing would just be on offering a different definition of real estate closing, but maybe later.
And I totally understand if you need to offer it in the community center and I get voted down, I understand. But I would ask y'all think through that one as it relates to the overall bill. Thank you.
Thank you.
Representative Reeves.
On line 160, the any attorney provision, I want to see if it's similar to some other statutes we have. Is that like a whistleblower or key tam or private attorney general provision?
It's even broader than that. You can bring it directly. You don't have to wait on key tam.
Okay. That's all the questions I see.
Thank you, Mr. Chairman.
All right, thank you. All right, we got a long list here. I would ask everybody to be on point and direct, and so we can speed this along. I'll start at the top of the list, James Jordan.
Mr. Chairman,
Yes, sir.
members of the committee, thanks for allowing us to be heard. I am Jim Jordan. I am a commercial real estate lawyer with Evershed Sutherland. I've been practicing law for 40 years in Georgia in the commercial space, former chair of the real property law section of the State Bar. Shelley Willis is here as well. I'll let her introduce herself.
Mr. Chair and committee, thank you for letting us come talk to you. I'm Shelley Willis. I'm a partner in real estate and finance at Troutman Pepper. I also was a former chair of the Real Property Law Section Executive Committee and spent over 6 years as the Deputy General Counsel of SunTrust and then Truist Bank. Thank you.
We have an informal working group of commercial real estate lawyers who are concerned about provisions in the bill that would, while intended to cover problems in the residential space, would affect the way that we close our commercial transactions. So we've been involved for a month or 6 weeks working on the bill, proposing revisions, some of which have been granted and some of which haven't. And we wanted to come before the committee and state some concerns we still have. I heard about a revised bill. We haven't seen a revised bill. The only bill we've seen is the bill that was passed by the Senate. So if there's revision, some of our comments may not be on point because we're not aware of any revision. I also want to make clear that we are very much in favor of remote online notarization. That's why we had the suggestion we want to make sure it applies to commercial transactions as well. We're very much in favor of technology, of course. In the commercial space, it's all about efficiency. It's all about using technology to leverage our practice and do it as efficiently and effectively as we can for our clients. And also, you know, we are concerned about any kind of fraudulent fraud that occurs, whether it's in the commercial space or the residential space. And we certainly would be in favor of protections in the residential space that deal with that concern that were discussed by Senator Tillery and others.
Let me interject here. We are dealing with LC 520529S. It's for anybody that's online listening to what we're doing so that they know. All right, go ahead.
Okay. So our concern, we have three categories of concern. One is what we see as a conflict with the Supreme Court's exclusive jurisdiction as to the practice of law, and that there are provisions of this bill that we think may run afoul of that exclusive jurisdiction, and I'll speak to that. Shelley is going to speak to some practical concerns we have about the existing bill, and then Josh Kamen and Brent Gilfetter of King and Spalding are going to talk about some practical problems that we fear this bill will have on the way that commercial real estate transactions occur in this state and in the city of Atlanta. Huge part of our economy, and we're concerned that this bill may have some unintended consequences that may have effects on the state of Georgia. This bill, in a lot of the conversation, dealt with notarization in the notary process. We have no problem with that. But I will point out that of the 16 pages in the Act, 11 pages by my count either revise the unauthorized practice of law provisions or insert new UPL provisions into the statute. So this bill is a lot more than just notarization. It deals with the practice of law definitions and the unauthorized practice of law definitions that have been reserved to the Supreme Court by the Georgia Constitution. In fact, our principal concern that I want to speak to goes to the heart of the bill as an impermissible intrusion to the exclusive jurisdiction of the Supreme Court of Georgia on the practice of law and the unauthorized practice of law. The cases are clear, and there is a red line, by the way, that may be, has it been distributed? We brought a red line, maybe in front of this gentleman here. That's a red line of the bill as passed by the Senate that has our suggested revisions to the bill, and there are some cases cited in the legend at the bottom of every page that deal with this exclusive jurisdiction that the Supreme Court has in Georgia. Any provision of a Georgia statute which impermissibly crosses the line into the regulation of the unauthorized practice of law is invalid, in my opinion. And that's illustrated by a case called Greca versus Omni Title Services. It was decided by the Supreme Court in 2003, and that case is cited at the bottom of every page of our red line. And what's interesting is that law dealt with a section which is being modified by this bill. It dealt with OCGA section 15-958 that dealt with who can bring an action alleging an unauthorized practice of law violation. And what that statute, what that case said, the Supreme Court said, we conclude that OCGA 15958, which is being amended again by this very bill, has been obviated, which is a fancy word for removed or replaced, by the creation of the State Bar of Georgia and the directives to it as an administrative arm of this court to investigate and prosecute cases of UPL. So what happened is that case, in that case, Greca, which was a private bar organization, sought to assert a violation of the UPL requirements, pointing to provisions in the statute that said that a private bar organization could do that. And what the court ruled was that the Supreme Court had the exclusive jurisdiction to be the plaintiff in those actions, and that they had directed or deputized, if you will, the state bar to investigate UPL violations. So in my opinion, Section 1.5 of this act that serves to add the attorneys and the Attorney General and the other parties is invalid, because the fact of the matter is, under this case, under Greca versus Omni Title Insurance Services, the Section 15958 has been obviated by the later passage of the State Bar of Georgia enacting legislation. So for that reason, we're concerned that that particular provision may well be held invalid by a future court if litigated, and we're concerned there are other provisions of the bill that could cross that line as well. There are cases, and I'm going to just cite two more cases, and then I'll turn the podium over to Shelley to talk about some individual provisions of the statute we're concerned about. But there are cases. There's a case called Georgia Bar Association versus Lawyers Title. It was dated 1966. It actually gave the court, it gave the legislature the right to pass legislation which is appropriate and essential in aiding the judiciary in their exclusive jurisdiction as to UPL matters. So we are not saying that the legislature can't pass any laws concerning the UPL or the practice of law. So where's the line drawn? In the Greca case I just mentioned, it's clear that if there is a direct conflict, if the Supreme Court has directly ruled on a matter, in this case by creating the State Bar of Georgia to deal with UPL, that the provision in the statute was invalid. So if there's a direct conflict, we think it's invalid, but if it's an indirect conflict, then it's unclear. And we think there are other provisions of this bill that indirectly are inconsistent with the exclusive jurisdiction granted the Supreme Court. And frankly, I'm concerned that this bill, if passed as it presently exists, may well be invalidated if someone were to contest it as a violation of the exclusive jurisdiction of the Supreme Court. I'm happy to take any questions that anybody has with respect to the UPL, unauthorized practice of law provisions, or we can let Ms. Willis talk now about the practical concerns we have about the statute, whatever the committee would prefer.
Since my board is lit up pretty well, I think we'll start with questions and then we'll come over here.
Okay.
All right. Vice Chair Reeves.
Thank you, Mr. Chairman. Just a series of questions. Does your firm do residential closings?
We do not.
Okay.
In fact, I would like to make it clear that I'm here as a member of the bar. I'm not here on behalf of the firm or any firm client. It's just members of the bar that we're concerned about provisions of the bill that were going to cause problems for the commercial practice of law.
Okay. And I think Chairman Tillery tried to tailor the bill to where it pertains to residential closings primarily, and that's what we're focusing on. Would you agree that it's wrongful for an out-of-state lawyer or a title company to draft Georgia real estate documents for a Georgia real estate conveyance?
I think that a deed needs to be conveyed, it needs to be drafted by a Georgia lawyer. I think that's clear under the case law and the promulgations of the state bar.
Okay. And Code Section 15, 19, 50, and the code sections following that, I mean, those are statutes passed by the General Assembly that set forth unauthorized practice of law statutes from the 1930s and 1970s, right?
Correct.
And the Supreme Court has allowed those to stay on the books for the last 40 or 50 years, right?
Well, I would say that the Greca case said that 15-1958 has been obviated by by the state bar's rule with respect to UPL. So I read that Greca case as invalidating 15-1958.
Well, 15-1950 gives a list of what is the practice of law.
Correct.
And one of those is real estate closings. The other one's given a title opinion.
Correct.
Those are reserved for Georgia lawyers under state statutes, right?
Yeah, exactly. I agree.
And that's still good law.
I am not aware of any problem with that law.
Okay. The federal bill that was referred to earlier, that's the Secure Act, right? That's bouncing around about electronic closings and notaries and things like that.
I'm not sure about that. I can't speak to that law or that bill.
You haven't looked at that federal
have
bill
not.
that's been proposed?
I have
Okay. If that federal bill passes, don't you think it's a good idea to have some robust laws in place in Georgia to make sure that Georgia continues to be a lawyer closing state?
I'm not, again, I can't speak to that law. Haven't seen it, have never read it.
Okay. You mentioned the state bar and the Georgia Supreme Court on enforcing the unauthorized practice of law provisions. Other than the 2017 case against Service Link where they were flagrantly violating Georgia law, can you think of any other enforcement actions that have been done in the past several decades to protect Georgia's rules about lawyers doing closings?
I'm not aware of any other cases. You know, there have been a lot of activity with respect to formal advisory opinions that addressed various issues and concerns that members of the bar had and strengthened some of those protections in favor of the bar and ultimately in favor of the public.
Well, here's what I'm concerned about. I mean, we had one case where you had an out-of-state title company and they were doing like thousands of transactions, thumbing their nose at Georgia law. And at that point, resources were devoted to stop that. But if somebody's doing a more limited number of illegal, unauthorized practice of law activities in Georgia, I mean, do you know if the state bar or the Supreme Court currently have the resources and the setup to deal with that, to police that?
I don't know. I know that the state bar has committees that are in charge of issues and concerns about UPL. It's an active committee. So I think they do have resources and people that are very concerned about those issues.
Okay. Representative Kelly?
Thank you, Mr. Chairman. I appreciate this robust discussion. I'm trying to wrap my head around all of it. Help me understand as policymakers here how far we can interject ourselves into regulating the practice of law. If any, like, can we, for instance, if there was a bill that was going to have to do with lawyer advertising this year, can we step in and do something like that, or where do we draw the line, just so we can kind of have just know broader as a Judiciary Committee about what we can do to lawyers and what we can't?
Yeah, that's a good question. I appreciate it. You know, in looking at the cases that I looked at, it's clear that if there's a direct conflict with a Supreme Court ruling or a Supreme Court delegated position taken by the state bar, then I don't believe the legislature can enact a law which would be directly in conflict. And that's why I have the concern about 15-1958, because that Greca case out there is in direct conflict with 15-1958 as I read it. Once you get out of a direct conflict, I think that there's probably a decent argument that those laws may be valid, because the legislature does have the right to enact legislation appropriate and essential in aiding the judiciary. So I think we just need to stay away from direct conflicts is my biggest concern.
Thank you.
All right. Whip Burchett.
Thank you, Mr. Chairman. Give me your name one more time.
Jim Jordan, Evershed Sutherland.
Mr. Jordan, thank you for your testimony. You're hitting on a question that occurred to me when reviewing the bill, and I'm going to stay along the same lines as Representative Kelly and Representative Reeves. So what authority does that case that you're citing to, what authority is the Supreme Court citing to where they have the exclusive jurisdiction for the practice?
It's the state constitution.
We're at it. We're at in the state constitution.
Let me look here for a second. It looks to me, I'm looking at this earlier case, the lawyer's title case, and the Supreme Court there talked about unconstitutional with reference to Article 5, and then parenthetically it says Article 6 question mark, Section 1, Paragraph 1 of the Constitution, which was then enacted or codified in a prior version of the Georgia Code that predates the OCGA.
So what does it say? What does that article say? Does it say right there?
It doesn't say what it says. It just says,
So is it the Supreme Court citing to one of their opinions, or they're citing to the Constitution?
you're citing to the Constitution. And I think it's clear if you look at the cases that in Georgia and elsewhere that the practice of law is within the exclusive jurisdiction of the Supreme Court or whatever the state is. I don't think there's any question about that as a legal principle.
So let me ask you this: if the Constitution, if there were a bill, say that by general law we passed a provision that allows for the General Assembly to remove or suspend a district attorney, is that a practice of law? Is that in the area of practice of law?
I don't have any opinion on that. That's way outside of what I do on a daily
Okay.
basis.
All right, I'm interested to look at the because what you're testifying to is kind of a flag that showed up for me, but I'd like to see what that. Give me the site one more time to.
The Constitution?
Yes.
I lost my page. But I can find it again. What I see.
What was the case? What was the case? Sorry.
Mention the case.
Give me the case,
Yeah,
Mr. Jordan.
The case name that cites that is, it's the Georgia Bar Association versus Lawyers Title. And the site on that is 222 Georgia, 657. It's Supreme Court, 1966.
Thank you very
You'll
much.
see the site to the constitutional provision in the first paragraph of Justice Cook's opinion.
Thank you very much. Appreciate that.
All right. That it? I think that's all the questions you have. All right.
Okay, thank you. Shelley Willis again, and I'm here individually again and not as a representative of either Troutman Pepper or any clients. And I'm also going to pull back a little bit from the Constitution and talk a little bit about commercial real estate closings in Georgia and really nationally. When I started as a commercial real estate attorney in 1990, we all came around a table and had a closing. Today when you buy a house, you come around the table and have a closing. Today, when you close a commercial real estate transaction, it's a rare event to have someone in a room at a table, and I can't recall the last time I, as the attorney, notarized the document. Over the past couple of weeks, I had to be out of town for a family emergency, and I continued to work on my closings. I had one of them that has a large piece of property that will be an industrial facility that has an old farmhouse on it that had been used as a residence. It will be a community center, but it's a residence today. In that transaction, there are multiple attorneys working on the transaction. We're lead counsel, and there's local counsel, and the collateral's not here in Georgia. But if the situation were flipped, and I were local counsel, and that property were here in Georgia, then I would risk the unauthorized practice of law unless I got back in my car, came to Georgia, sat around a table, and brought everybody together and notarized all those documents. So what I'm saying is what we want to make sure of as the bill moves forward, if it moves forward, is that we are ensuring that we're pulling commercial closings out because they're just not the way that they operate anywhere, not just Georgia. And we do appreciate Senator Tillery and the proponents and everything they did to help sort of address that fact. And I wanted to just sort of target a couple of places here, and thank you for the updated bill, for being able to look at that and the change that was referenced. But really, line 61 and the definition of real estate closing, as you'll see in the black line that we've provided, we did have some conversations really kind of at the last minute to try to make some changes before it went before the Senate but with a focus on the residential piece of property as opposed to, is it a commercial or a consumer transaction? There are a number of scenarios, and that's what this additional definition attempts to do, where we inadvertently will be bringing commercial transactions within the structure that may work for real estate for residential closing, but not a commercial closing. Senator Tilley mentioned a build-to-rent sort of transaction, but that's just one transaction. The one I just described with a clearly commercial transaction that has an incidental piece of residential property is another one of those. A foreclosure is another. And that's a conveyance in Georgia, the way that Georgia conducts closings, whether it's a deed in lieu or a deed under power taking at foreclosure. Without these changes, would be brought within this definition. So I can take additional questions, but I wanted to give you that bit of background on the real significance of making sure that if this moves forward, we're very careful with the definition of real estate closing, which is intended to protect the consumer, not inhibit commerce in Georgia. The next one that I wanted to just mention is at, well, line 159 just points out the addition of any attorney. That's already been mentioned, but just wanted to tie you to where we are looking at that. And then what we would view as more of a clarification, when you get to line 296, and I know we've talked about the fact that this is an attempt to move Georgia forward with electronic and other opportunities for notarization. Because we sort of addressed the issue of commercial closings in the definition of real estate closing, we then pulled it out of the section on the remote notarization. So without this insert that we've proposed at line 296, commercial closings don't get the benefit of online notarization in any format. So that's what that is endeavoring to do. And those were the points that we wanted to add, and I'm open to any questions.
Vice Chair Reeves.
Ms. Willis, on residential closings, they use a HUD-1 settlement statement, right?
Mm-hmm. I believe so.
So if somebody sells the family farm and they have a house on 50 acres, and that's not going to require a HUD-1, that would just be a normal closing, right?
In that transaction, there was no HUD-1. That's correct. It was part of a commercial piece of property, but it had a 1 to 4 family residence situate on it.
Okay. And so there is a way to determine is it residential or commercial. If it requires a HUD-1, then it's going to be a residential transaction, right?
Potentially, if we went down that route, yes. I mean, that's not what's currently contemplated here.
Well, but I think the bill tries to define residential, and as a lawyer, if it's residential, you do HUD-1. If it's something that is not really just a house, if it's a farm or a property that's being developed, then you could do something other than a HUD-1, right?
With all due respect, as the attorney who is potentially going to be convicted of a misdemeanor or felony for unauthorized practice of law, I need to be comfortable with something other than, the bill doesn't make that distinction. The bill should make a distinction between a true consumer transaction and a commercial transaction. And then I would agree that it's addressing consumer. But as it's written currently, because of the focus just on the type of property that it is, as opposed to the nature of the transaction and the nature of the parties to the transaction, it's overbroad.
I think that's a federal regulation. If you do a residential transaction, you're going to have a HUD-1 closing statement. So that would be your bright line, right?
It could be, but this statute does not provide for that.
Well, federal law does, right?
Not
I mean, how do you decide whether to do a HUD-1 or not?
Because, well, it's the opposite of it's the inverse of what you're saying. You're saying if there are reasons for someone conducting a residential closing to use a HUD-1, and there are issues if they don't. But under this statute, if I do certain things that are clearly a commercial transaction, I'm still scooped up within the ambit of it.
Like what? Tell me what.
Like the closing I just described with the industrial property with the one residential farmhouse that ultimately will be a community center.
Well, I thought you just said that's not a HUD-1 residential transaction.
We did not use a HUD-1 to close that transaction.
Okay. So
But
it's
that
not-
is not what this statute would protect me against. There's nothing about a HUD-1 in this statute.
And you said something about foreclosure. What are your concerns about foreclosures?
So in Georgia, foreclosure is non-judicial foreclosure, so there's a transfer of a deed under power of sale in connection with the closing. And either a lender would take back the property by making a credit bid against their loan, or a buyer may come to the courthouse steps and knock off the property and need to have cash. And so there is the conveyance of that property by deed under power of sale, in exchange for either the credit bid or the cash. And that, again, fits within the definition of real estate closing that is otherwise set out here.
And those documents in Georgia must be drafted by an attorney, correct?
The issue is there in many of these cases is not that an attorney is involved, but the way the statute works, if you fall within the statute, you have to be sitting around a closing table. The attorney has to notarize the documents. There has to just be one attorney, and it has to all take place in Georgia. It describes a residential real estate transaction. And when I'm taking that credit bid on the courthouse steps, I'm not following what's prescribed here.
Well, that's the actual conduct of the foreclosure. I think what this bill addresses is the deed, the foreclosure deed, the deed under power of sale.
Which
so
all happens.
tell me how you think that a deed under power of sale should be executed. I mean,
If it is a commercial piece of property, if it's a commercial transaction in essence, I mean, it should follow all of the recording requirements that are set out in Georgia and any of the notarization requirements that we end up with.
Okay.
But it should not be, it should, I mean, me as the party conducting the sale should not be conducting the unauthorized practice of law if I haven't actually notarized that deed under power sitting around a closing table in Georgia and receiving the funds there.
Yeah, but that's two separate things. The actual foreclosure on the courthouse steps, that's different than the deed. The deed is done later after the transaction.
Not really. It's all sort of contemporaneous on that day.
You're saying that the foreclosure documents are signed on the courthouse steps.
They're already signed and tendered to me, complying with all current requirements for Georgia notarization and recordability. They just don't have the grantee's name yet because that's what's determined at the close
So
at the
you're
courthouse.
saying there are people who are signing foreclosure documents in blank before the sale occurs?
And then they're authorizing a completed document.
And you're filling in the grantee's name with the execution already having taken place of
With
the deed?
their authorization of a final document.
And what's that final document?
That deed. They have to authorize that, yes, I authorize you to insert that grantee's name in that document.
Okay. There are different ways of doing foreclosures than that, and I'll leave it at that.
Other questions?
Thank you, Mr. Chairman. This may be for Mr. Jordan, reading up a little bit on your history. I'd say that you may very well be very, very familiar with the Greca case, just from the firm that handled part of that case. Is that right?
I see that our firm handled it, and I wasn't aware until I read the case.
Okay, just curious, curious. I was thinking you
I
might.
wasn't aware. It was our litigators, and I wasn't involved.
Sure, sure.
In any way, shape, or form.
My question is this: State Bar Act 1963 was when it was passed, correct?
In the 1960s, at some point, yes.
I'm not indicating you were there when they signed it by any means. Interesting to me, though, is that the legislature created the state bar. In theory, we could also do away with the state bar. Is that correct?
In theory, but I think it would be, the Supreme Court would have something to say about that, because the Supreme Court has deputized, if you will, the state bar to handle a number of matters in their jurisdiction as to UPL. I think the Supreme Court wouldn't permit that to happen.
Okay, so let me get right down to it. Could the legislature not, since we created them, also pass by general law direction on how to run the organization, promulgate rules for them by legislative act?
Again, I think the Supreme Court would have a big problem with that. You could try, but I think you'd have trouble with the Supreme Court. I think that probably would be invalid.
Even though the legislature created a state bar?
Because
Okay.
the state bar can pass a law which aids the Supreme Court in their exclusive jurisdiction. But it's one thing to aid them, it's another thing to dictate how it's all going to be, how it's all going to come down. And I don't think, promulgating all the rules and how they operate is the same as aiding the Supreme Court in their exclusive jurisdiction as to UPL matters.
Okay. Thank you, Mr. Chairman, for indulging me on that.
Thank you, Mr. Chairman. Thanks to both of y'all for being here. I think I may have lost the thread a little bit, and I want to make sure I understand your position. The red line that y'all gave us, or the blue line, this is how y'all propose we change it to make sure that we are excluding commercial transactions. Do I have that right?
That's right.
And if commercial transactions were excluded, to your comfort level, would you be in support of the bill otherwise?
We would not be opposed to it. I think it still has the potential UPL issues, but would not be opposed to it were they addressed.
Okay, understood. Could you tell me, we received the letter that was signed by, I think, both of y'all and a few others. Could you tell me a little bit about how this group came about, and could you clarify whether or not it is any official group put together, sponsored, sanctioned by the state bar, or if it is truly a conglomerate of individuals, and who is the ringleader?
Sure. It is exactly the latter that you described, and it came about, as I said, fairly in a fairly brief time period because we heard that of the bill, and that it was coming before the Senate Judiciary Committee, and so there are a number of us who have practiced commercial real estate together for a long time, and have served on the executive committee and or chaired the real property law section, and have served on a few other American College of Real Estate Lawyers, some other organizations, and then just worked together a lot. And so as we learned of it, then we shared it with some others of us, and that's why, in particular, I think, and again, thanks Senator Tillery and others for beginning to address peeling commercial out of this. But just, as we looked at it more and had a little bit more time with it, realized that, that there were a number of additional other implications that would impact, Georgia commerce and Georgia commercial real estate.
Were there any corporate interest involved in bringing y'all together, and any informal communications, anything like that?
No, and we're, as we've said, we're not here representing our firms. We're not representing our clients. We're here as commercial real estate practitioners who understand how commercial real estate transactions function on a national basis.
Thank you.
Thank you.
Whip Burchett.
Well, I had enough time to study, Mr. Jordan. I'm getting caught up here. I'm reading from Georgia Bar v. Lawyers title. In the view of this historical recognition by this court of the right of the legislative branch of the government to enact legislation in the aid of the judiciary in the performance of its functions, we hold that the statute under attack, which is the statute defining what the practice of law is, defining the practice of law, is not a denial of the constitutional powers of the judicial branch of the government, and the trial judge correctly so held. So in that case, as I understand that provision in the case that you cited, Georgia Bar v. Trial Lawyers title, saying that the General Assembly defined what the practice of law was, and because we weren't overstepping our bounds or denying the judicial branch the performance of its function, then it was upheld. And so what is different about the redefinition here than back then?
My concern is not on the section that defines practice of law. It's not on 15950 because there's no direct conflict there. My concern specifically is on 151958 because that flies directly in the face of the Greca case, where the Greca case said that there already was Supreme Court action with respect to who could bring an action, and that is the state bar. And so in that case, they invalidated. They said that Greca didn't have standing in that prior case because even though the statute gave them standing, they said that wasn't a valid grant of standing to Greca. So my concern is 151958, not 15.
Oh, so you just put the note, the blue note on every page, is that right?
Exactly.
Okay, all right. So it wasn't pertaining to us defining the law, and you think there's no problem there?
I don't see any particular problem there.
Okay. And then one more question. So with the General Assembly enacting our Evidence Code and our Civil Practice Act, do you think that is us overstepping our bounds when we are dictating how you practice law in the state of Georgia?
I don't have any opinion on that. It's above my pay grade.
All
I'm
right.
just a commercial real estate lawyer.
Thank you, Mr. Jordan.
All right. Mr. Jordan, okay, we have a question. Representative Holcomb.
Thank you. So I want to make sure that I understand, and I think, Mr. Jordan, it's good to see you again. In full disclosure, I used to practice at Sutherland. What is the practical consequence? I think I agree with you in terms of the reading of Greca versus this section, and it looks like it was never updated to take away that authority, which the Supreme Court clearly eliminated. But what is the practical import of it in terms of your practice or of others? I don't do this. This is outside of my area, so can you just help me understand? I understand that if we cure the language on the commercial part, that will satisfy, but what are the consequences on this?
Yeah, that's interesting. Thanks for asking that question. Because 151958 isn't limited to residential transaction, it applies to any UPL. So it applies to any alleged action, which is UPL, either in the real estate space or the litigation space or the corporate space. Any lawyer in the state of Georgia who had a bone to pick with another lawyer could claim that was a unauthorized practice of law and bring a lawsuit in the Superior Court and cause all sorts of problems. Without having the right degree of wisdom or experience on what UPL means. I think the state bar has that expertise and has that experience, and they are the proper party to be bringing UPL actions. So the concern I have is that 151958, I think, was invalid as to, per the Greca case, and we're adding additional plaintiffs to a provision which is already invalid. So I think that what happens practically is if that were enacted as is, and there were allegations in the future, cases brought, I think they would all be subject to a defense that it was that particular statute was unconstitutional for violation of the Supreme Court's exclusive jurisdiction.
I understand. Okay. Thank you.
Any other questions for Ms. Willis or Mr. Jordan? I do have a question. 441413, the Good Funds Law, that was enacted as the Great Recession was hitting. Somebody bounced a bunch of closing checks, and that was a statute that was enacted after that pertaining to closings and the procedures for funding on closings, right? And that's still good law. Supreme Court wholly approved of the legislature laying down that law about how to handle closings, right?
Not aware of any problems with that law.
Okay. Yeah. And I think Representatives Oliver and Bruce worked on that back then. So, all right. And, okay, and did you have something?
Yeah, I had one other comment that I wanted to make. When it comes to these categories of additional transactions that are part residential and part commercial, another example is the assemblage of neighborhoods. There are a lot of office buildings and commercial projects in this town that were built on former neighborhoods, and a developer comes in and he buys 50 houses, and it's a big commercial transaction. You have 50 people coming in to close houses day after day after day, and at the end of the transaction, the houses are all demolished and a nice new office building or what have you has been built. Under this law, under this definition of real estate closing, that kind of transaction would be would be governed and subject to the act because it's a 1 to 4 family housing transaction, even though it's clearly a commercial transaction. So what we're trying to establish, we're not trying to say that those transactions should be only by commercial lawyers. We're just saying that clearly residential transactions are done by residential lawyers. Clearly, commercial transactions are done by commercial lawyers. If there are some that are hybrid, that are a little bit of this, a little bit of that, then anybody can do them. It shouldn't be clearly within the purview of the residential lawyers, because we need to be able, if our client comes to us and says, we're going to assemble 60 houses for a new office building or a new industrial project, it seems to me we need to be able to do that transaction, because it's a commercial transaction. It really isn't a residential transaction.
Because the other thing is that this statute dictates when it's in the residential bucket how it can be done. Everybody's going to sit around a table. The attorney's going to notarize the document. Everybody's going to be present in one room. There's going to be one attorney, et cetera.
Well, I thought the residential lawyers get to do the electronic closing under this bill. I thought that's the focus of this.
Sure, they can. Yeah, that's permitted.
Yeah.
But the transaction.
So they're not going to be sitting around the table. They could have an electronic means closing if it's residential.
Right, but when you read it, it's still, it's an electronic closing that is the way a residential closing operates, not a commercial one.
Okay. And I'll yield to my chairman, but I do have a follow-up question on that point.
Go ahead.
All right, on those assemblage things, I've seen one or two of those in the last 21 years in Gwinnett. And usually a developer has a contract to purchase the house contingent on rezoning.
Right.
Right?
Correct.
And do you use a HUD-1 residential closing if that's the case?
In my experience, this goes years ago. I don't believe we did.
Okay.
Because he didn't have one contract. He had 61 contracts with 61 different owners. To buy their properties for double the value. Everybody was happy and everybody was glad to get to the closing and get their money.
And they're rezoned. It's no longer a house. It's
not to
zoned
be
for an
used as a
apartment
house going
or something
forward.
like that. Okay.
But it is a 1 to 4 family residential dwelling, and that's the concern we have.
Thank you.
And I did not get to introduce the judge.
Oh, okay. All right, I don't see any other questions for you. Thank you.
Thank you.
Thank you.
And while we're in transition here, I want to recognize Judge John Morris, who's president of the Council of Superior Court Judges. Are you our Judge of the Week?
I am.
All right. Thank you for being here. Oh, sorry. All right. Yeah, I guess Josh Kamen and Brent, do y'all want to do it together?
Yeah, we'll
All right, come on up.
He doesn't let me talk very much.
I don't let him talk very much.
All right, introduce yourself.
He's
and
a
you
lot
have the
younger than
floor.
me, even though he doesn't look it.
19 years of working for you.
I know, it's terrible. Hey, folks, thank you, Mr. Chairman, for having us here today. My name is Josh Kamen. I'm the managing partner of the Atlanta office of King & Spalding. I'm a commercial real estate lawyer. I'm a member of the American College of Real Estate Lawyers, which is our most esteemed recognition and group in the country, along with Jim Jordan and Shelley Willis. And I'm a former member of the Executive Committee of the Real Property Law Section of the State Bar of Georgia. And I also sit here today individually, even though I gave you that criteria. And I'll let Brent introduce himself.
I'm Brent Goldfeder. I'm a partner in the commercial real estate group at King & Spalding. It's my 19th year at the firm, and I've worked with Josh and all these others. And I'm here individually, not on behalf of the firm or any individual clients.
Okay, before y'all get started, is y'all's testimony any different than what we've heard so far?
I'm going to help you with that.
Okay.
Okay. I'm going to shorten this up a bit because you all asked a lot of great questions and covered a lot of the stuff that we were going to handle with Mr. Jordan and Ms. Willis.
Right.
So I just want to add maybe a clarification point and one additional point. If you have questions, happy to take them, but that's not it. Just to be clear and to answer your question, we are all in favor of electronic notary. In fact, we are big proponents of electronic notary. And if that's all this bill was doing, we'd be all for it because we are all for it. And we practice with clients who have interests in many different jurisdictions, and it's a good thing, that's it. Where we have issue, it sort of goes in a couple of cascading places. And that's where I think this bill is troublesome. I do think, as Mr. Jordan and Ms. Willis noted, the entry of the unauthorized practice of law provisions and the penalty provisions in particular are very problematic. along with the fact that there is over-inclusiveness in commercial transactions, which will impact, and I can just tell you they will impact the choices of our clients, or clients that I've experienced, in terms of where they do business. It will add cost to deals, and in adding cost to deals and trouble to deals, that's commercial decisions that people make that very well may steer people away from doing a deal in Georgia versus doing a deal elsewhere. So just to kind of hit the highlights of where that is, if we have to make a choice, we'd very much like to see an electronic notary bill pass. I'd rather see it very much scaled down so that we don't deal with things that could cause you all problems or issues with acting outside your particular jurisdiction, whatever that may be as you interpret it. And then likewise, we're concerned about some unintended consequences if you did pass this, relating to the commercial piece that was alluded to before. But also, I think there's some other things just to put on the radar screen. You have the potential for cottage industries of lawsuits that, candidly, we have no interest in, right? I don't really want to see lawyers suing lawyers over bad real estate deals as weapons, and I think this bill, as drafted, allows you to do that. I don't really want to see our courts overburdened with petty actions. We've got enough problems in our courts right now where we need to get cases through them. This whole line of other cases to bring, where we already have the Supreme Court that has jurisdiction over it with the bar, we don't need to add that to our already overburdened court system. And then on the commercial side and the like, where the overlap, we're known as a very friendly state to do business. Governor Kemp always touts us as the number one place in the union to do business. If we start having questions about whether you can foreclose appropriately or having challenges to your foreclosure, or whether you can do the deal where you're buying the factory that has the caretaker's house on it, and whether you did it the right way or not, and you're getting challenged and sued, that's not good for business, understanding that there's already regulation of that out there right now. Right? We don't need to add this over top of it. So with that, I don't need to go any further, but I wanted to make those points just so as you're considering all of this, you consider it. Again, in sum, our suggestion would be pass an electronic notary law. Like, we think that's a great idea. Just as drafted now, this isn't the one to do it.
Okay. All right. Representative Oliver?
Thank you, Mr. Chairman. I'm thinking and puzzled over the unauthorized practice of law, and I'm looking at as you noted, the word attorney on line 160, seeking injunctive relief. I'm putting it in the context of a foreclosure injunction, which I've done. Mm-hmm. Why isn't, when I move to enjoin a foreclosure based on the lawyer not sending effective notices under various statutes, why isn't that similar to what an attorney may be doing in this particular statute?
Well, in this particular statute, it's and pardon me, I do want to look at this one more time. So your question specifically is what? Why is it different for a lawyer to seek injunctive relief for the unauthorized practice of law versus an unauthorized foreclosure?
I think that in injunctive relief actions to stop a foreclosure, I'm just using that as an example. I, as an attorney, am making allegations about the failure of the attorney to send various statutory notices or other technical requirements of a foreclosure process.
Is your claim against the attorney?
So I'm trying to think
or
why
is your
this is what I'm doing normally in trying to enjoin foreclosure is not similar to the argument you're making about its unauthorized practice of law, for me to say the lawyer for the lender is messed up in these specific statutory
But
ways.
when you bring that claim, I believe, and I could be wrong, I believe you're making that claim against the party that is foreclosing, not the attorney.
Sometimes could be the attorney in there too, though.
But I think the attorney in that case is acting for the party that's actually foreclosing, that, for instance, holds the paper. I think the distinction here is you wouldn't be doing that. You'd be actually making attorney-to-attorney claims, and that's where I think there's a difference.
And I think your answer is right for, I'm satisfied your answer is right for a good many of, I'm just using enjoining foreclosures, but not all. So I'm just kind of troubled about why the allowing an attorney to seek injunctive relief because there's been procedural errors is different. after, and then I'm looking at 165, after an investigation has been made. I'm trying to figure out how that ties into the argument you're making, because the investigation in 165 could relate to state bar, calling a state bar, which I've done many times to ask questions about certain practices of lawyers and relied on it. Informal questions asked.
I mean, you're also bringing those injunction claims on behalf of a client. This is dealing with attorney on attorney crime. And I mean,
The attorney making the claim about violation of the notary law is doing it, is representing the buyer or the seller over there. So.
Yeah, but you represent a client, which is different than what this bill is proposing to do.
And that's where I'm troubled.
Yeah.
Representative Holcomb.
Yeah, thank you, Mr. Chairman. Again, since this is outside of my practice area, I need some help. One of the things that you said was that this would lead to attorneys suing attorneys over bad real estate deals. Can you explain what you mean by that?
Sure. What we don't want to do is give grounds to folks to weaponize the practice of law, right? So if and you can envision these are all speculative because again, this is not law and it's not how the rules are enforced today, right? But you could think of an instance of the Hatfield and McCoys of real estate closings, right? Where suddenly one of the weapons or the arrows in the quiver of one is to bring these claims against another because of thoughts of territoriality, right? These are things that you could speculate that could happen because suddenly you have this now codified. One of the good things about how our current system is set in place is you don't have that opportunity. Everything does run through a process. And this now, when you break down that process to have it be one where it's attorney versus attorney, we can't always expect that everybody does what you would expect them to do or what you would prefer or hope that they do. And that's a concern that we have.
Okay. All right, that's all the questions I see.
Great,
Thank you,
thanks.
gentlemen.
Appreciate your time and consideration.
All right. And I have Amy Huskins.
Yes, I'm going to defer.
Okay.
I've answered all the questions.
I also have, I think they're in support of the bill, Kate Hoskins, Larry Feldman, and Joe O'Kelly.
We're going to defer to Senator Tillery.
All right. All right, Senator Tiller, if you want to come back and give any closing remarks.
Thank you, Mr. Chairman. 90 minutes ago, we began talking. I find it, I appreciate the comments, but I think it's interesting that they didn't really focus on the closing part. They focused on, to an extent, the unauthorized practice of law point. And if you're worried about being charged with unauthorized practice of law, don't practice law unauthorized. That's the only point there. The second thing is I'm not nearly as good of an attorney as the ones that you've seen. They are smart and they've read more case law than I will ever read. But the case cited as the reason why we could not act was a case where the Supreme Court actually said they affirmed the actions of the legislature. So I think that that's pointed to say, if this affirmed those. I understand reading the gloss out of it to say, but if you did this, it wouldn't be affirmed. We're actually citing a case that was affirmed to say, hey, you can't do this. Because if you did this, it wouldn't have been affirmed. I just think that's an interesting argument. Thank you for your time today. I think this moves the ball forward. I'd ask that you please not amend it any further. We really have taken a lot of them. And death by 1,000 paper cuts or death by 1,000 notary stamps. I think we're where we are now, and I'd ask that you consider the bill as a whole. Thank you.
All right.
Move do pass.
All right, motion and second. Who's number 7 down there? Stoner? You, is it you?
Yes.
Okay. Oh, gotcha. All right. Any further discussion on the bill? Any amendments? Hearing none, I'm sorry? Just wanted to make sure that was the will of the committee.
I didn't think the author was willing to take any amendments. Is that correct?
Right.
Okay.
Which is far cry from no amendments. So that's okay. All right. Hearing none, then all those in favor of the passage of this bill say aye. Aye. Any opposed? One opposed. All right, Bill, two opposed. Bill passes. All right. You got one more?
I ask Representative Reeves if he doesn't mind to carry that bill. Thank you. Mr. Chairman, the next bill that your committee's been so kind to allow me to present is Senate Bill 426. It's LC number 491658.
Did you need the Commissioner of Insurance in here?
He
may have
had to step to another meeting.
Okay.
I don't know of anyone who opposes this, except I heard some last week. But this is a tort reform measure that's championed by the Lieutenant Governor concerning direct action. As you know, in our state right now, you can directly sue an insurance carrier when it's related, in most instances, and I'm oversimplifying, when it involves a motor or common carrier. Most states have done away with that provision. Georgia has not. And in this instance, working with my colleagues in the Senate, I appreciate them, the Senate Judiciary Committee members, and truly the Lieutenant Governor, we were able to strike a compromise where plaintiff's attorney said some instances here cause us concern when we try to serve, whether it be a truck driver or the motor carrier in a direct action. If we could do a trade-off with service, we think we could do a trade-off with the naming, the exact naming of the insurance company. That's the language that was struck here as a deal, and if there are any questions, I'll answer them, but I'd ask the committee favorably pass Senate Bill 426.
All right, questions by the committee? I don't see any. What's the mood of the committee?
Move to pass.
Got a motion and a second. Any further discussion? All those in favor of the bill say aye. Aye. Any opposed? All right.
Thank you,
Bill's
Mr.
on.
Chairman. Y'all have a good afternoon.
All right. Senator Cowser.
How you doing, Judge?
Good.
I always want to call you Judge.
Good to see you.
Good to be here. Thank you. You ready?
Yes, sir.
All
Whenever
righty.
you are.
I'm ready to go. This is Senate Bill 433. It is an attempt to increase the ability of donors to enforce the intent behind gifts that they may give to various charitable organizations. You may have heard things in the press where somebody have given money to fund a certain scholarship or whatever, and they learn later that the institution did not honor their wishes in that. It's easiest, especially dealing with a group of lawyers, to start with the definitions because they're important here. On page 232, line 32, defines endowment agreements. And this bill only applies to endowment agreements as defined here. That is a written agreement between the charitable organization and a donor. It has to be accepted by the charitable organization. It has to be in writing, and it may include donor-imposed restrictions on the conditions or the use of the contribution. So it's not if it's a verbal gift or request or observation. It must be a written agreement. It must be accepted by the recipient, by the donor institution, to be bound by those restrictions. Now, wise people that draw these up may take advantage or think, these may last for a long time. They're trying to have a fund of money usually that your interest or earnings from it are funding your purposes over time. So they're understood often to last for many, many years. And so wise donors will have a secondary use of the money in case the original use evaporates for whatever reason. I have used as an example, say, the Bill Gates Foundation, they're focused on eliminating malaria or some diseases in Africa. Well, if they succeed, what are you going to do with those billions of dollars? They probably have secondary directions on what the next illness or whatever they may want to go. That can be in the agreement. Many of these agreements will say that once the mission is accomplished or my funding that I've asked for has been done, the remainder can go into the general fund of the, let's just call it a university or whatever the organization is. But for this bill's purposes, this only applies to these written type of agreements that are agreed to by both parties, which makes a big difference in the equities behind this. Also important in the definitions at line 19 and 22, we define charitable organizations and charitable trust. Many of these philanthropic organizations are set up as trusts. Some are corporations, and this definition of charitable organizations refers to the Georgia Code on charitable organizations that has charitable corporations. So it's a variety of business entities, but they all must be intended for charitable purposes, and that's why it references 501c3 or 501c4 as defined by the Internal Revenue Code. So we're looking at gifts to these type of charitable organizations from donors, and the bill's intent is to give an enforcement mechanism if the charitable organization fails to honor the intent of the donor as expressed in the endowment agreement. And there is not a specific cause of action in Georgia law today, and this creates it. It gives you a 4-year statute of limitations. It needs to be brought in the Superior Court of the county where the charitable organization is or its principal place of business. It cannot seek damages, cannot seek the return of your money. It's essentially a mechanism for declaratory or equitable relief to force the organization to honor the intent of the donor. It also gives the organization rights to seek clarity or to get judicial intervention, declaratory relief, equitable relief. The example I just gave you, if the primary intent of the donor has dissipated or disappeared, and just as times change, it would allow for that. And that's what the bill does.
All right, thank you. You got several questions here. Chairman Smith?
Yes, thank you. I want to say hello again to my
Hello,
fellow
Chairman.
Southern Conference graduate from the Blue Hose of Presbyterian.
There we
Good
go.
to have you with us, Mr. Chairman.
Thank you.
Just checking, under this bill, if you had the statewide organization for cow tipping, PETA wouldn't be able to try to get the names of those individuals and go after them for cow tipping, would
they?
it?
They wouldn't, and this does not allow for intervention from people like that. You'll notice that it's set up. I'll see if I can find my line. On lines 48 to 50, it tells who may bring the action. It's the donor, the donor's direct descendants in the event the donor is deceased. The donor's legal representative can bring a civil action. Some reason we said legal representative, it could be the executor of an estate. It could also be a trustee of a charitable foundation or fund that made the donation. That's who gets to bring in. Any outside party that maybe was even a beneficiary of it would not be allowed to bring the action.
Okay. Thank you.
It doesn't prohibit cow tipping.
Representative Oliver.
Thank you, sir. I'm looking at paragraph D, beginning on line 62. I'm satisfied that this bill is not going to impact the mistakes that I see made in will. I'm giving it to the Rose Cemetery lot when, of course, it didn't exist anymore. But this seems to limit your remedy to what you've defined as the endowment agreement. And what if the endowment agreement doesn't have that provision, doesn't say anything about remedy? I'm trying to figure out exactly how this would work, because if it were my will that was not used, I'd want the money returned to the estate, and you're prohibiting that in line
No, it
66
doesn't prohibit
and
that
60. Yeah, it does.
if that's in the agreement.
But what if the agreement doesn't have remedies? You know, agreements aren't always detailed as they should be in the state documents. I'm worried about the remedy provisions, how you've limited them.
But you're right. Sometimes these agreements don't go into as much detail as would be beneficial for the recipient to give them direction in the future. And that's really what we're trying to address, to give a way for a court to step in and essentially give equitable solutions to what I guess they're almost trying to be what would be most consistent with the desires of the donor. There's a case I'd reviewed some cases in some other states that showed some problems why this was necessary. And for example, there was one case where a donation was given to fund scholarships to a nursing program at a school. Well, it turns out the school discontinued the nursing program. Right. So there was a lawsuit brought to get relief from that. And the remedies looked at was, well, we could send this or redirect this donation to another nursing school that was consistent with the mission of this school. As it turned out in that case, before the court ruled, they reinstituted a nursing school, and so it never came up. But it gave a great example that, you know, sometimes it may be that there are changes and make it impossible for the recipient to continue to honor.
You're not concerned that the language, the court shall not be authorized to order the return of the contribution to the donor, that's not overly restrictive?
Well, I won't be like Chairman Tillery and refuse to have any amendments here. I was surprised. I didn't know I had that ability to just say no amendments, but I do. I love the legislative process, and this we do perfect our bills with the bicameral legislature. And if you think that would be helpful, I would not oppose that. But what we didn't want these were to be used as a weapon to return the money. The problem is, so many times these charitable organizations have spent it, or it's not there, or you know, and so you surely don't want to impose another burden on them, because these are, as defined in this bill, charitable organizations. You know, they are not for-profit companies or whatever.
Emory eliminated its journalism program, but it still accepts the Cox money for the chair of journalism. They figured that out, how to do that. But
a lot of times the parties, they reach agreements.
Right.
You know, when the original purpose has either been accomplished or is impossible to continue doing, and the parties can amend these if they'd like to, but I think this is for where they can't.
I leave it to anybody else on the committee that thinks this is a concern, but limiting this right to only where there is a written agreement leaves the court with absolutely very, very little or no power when the agreement might not be specific enough.
Okay. Representative Bruce?
I was going to ask the same questions you were asking. But given what you just said, I'm not sure I understand the point of the bill if it can't do anything.
Well, the court can order the institution to honor the agreement and spend the money as
if the money has
intended.
already been spent, to her point, if the money has already been spent and they don't have it to redirect it back to wherever it was supposed to go, and the court can't do anything to make them come up with the money, I don't understand the point of the bill.
What I'm trying to do is encourage charitable contributions. And many people, when they give money, they want to give money, but only if it's going to be used for what they want it to be used, for what's important to them.
Mm-hmm.
And so if they believe that strongly in it, that they put it in writing and require the recipient to agree to it and sign and say, I promise I'm going to spend it for this. You know, I want that to happen. I want to encourage as much charitable giving as we can, and people are, this was brought to me by a philanthropic organization, a group of very wealthy donors in America that are concerned about their intent being honored and looking for a tool to do it other than just punitive in nature, to seek attorney's fees and monetary damages and things like that. So I recognize some of the limitations of it.
And I understand what you're attempting to do. I just don't know that this does that. And that's why I'm asking the questions, you know, so, because what it sounds like, and I'm not a lawyer, okay, but what it sounds like is that we need to look at almost forcing a contract to be made when you make these major donations like you're talking about, that somehow that you require that they put it in writing, and that in that document that you're writing, you would include remedies if they don't do what they're supposed to do. It seems like we're trying to fix the problem with something that doesn't fix the problem.
Vice Chair Reeves.
Couple of questions, Senator Cowser. Philanthropy Roundtable is that organization you mentioned,
That's
right?
correct,
And
yes.
they're a national group who thinks up model legislation to help facilitate donors being charitable in the future. And a lot of nonprofits here in Georgia get their money from those national donors. And one question they've started asking is, have y'all done things like bills like this with donor intent? Isn't it true that your bill gives a framework, a legal landscape for donors to have confidence that the money is going to be used the way they want it to by having a method to get that decided up front that will be enforceable? Isn't that what this bill is doing?
That's what I'm trying to do. You stated much more eloquently than I have so far. Thank you.
To follow up on Chairman Smith, I am proud to see there's no Southern Conference team or college on this list, UGA, none of our Board of Regents schools. We are honoring donors' wishes right here, but this will bring in more national donors who ask, do you have that landscape they're familiar with from many other states, right?
Especially for scholarships. People that want to dedicate a scholarship in a certain program or in their name, they want to make sure it's done. But, of course, representing Athens, we have vetted this through the university system and the University of Georgia. They're all fine with it, no concerns.
Okay. Representative Oliver.
I just want to offer an answer to Representative Bruce's question. This is going to be for a very few number of wills being written, but it's going to encourage those agreements to be written. The average will that I draft that says I want to give $10,000 to the church is not going to have.
It's unrestricted.
I'm not going to bill another hour to do an agreement.
Right.
So this is going to be for a select, narrow group of donors.
That would be my impression.
Yeah.
All right. I believe that's all the questions we have. We do have a couple of folks that want to talk on this bill. Karen Beaver.
You need me to move or just move the mic? How do you operate?
Want to maybe slide over and let her have the hot seat there?
Thank you. I'm Karen Beaver. I'm the CEO of the Georgia Center for Nonprofits. I've been CEO there for 26 years. Our members are nonprofits, but also major philanthropies across the state. We have 5,000 of those. So they span from the Woodruff Arts Center and Care to the Colquitt County Arts Council. And you are correct that this bill actually would just affect those endowments, those gifts slated as endowments, right? But I want to submit to the committee that the model legislation follows, it's called MIMFA, right? Uniform Prudent Management of Institutional Funds Act. And so this particular roundtable proposal is model legislation for that. Georgia already follows all of MIMFA. We have very strenuous protections. What this particular legislation does is it raises the current threshold, or it lowers the current threshold from $100,000 to $25,000. And it also changes the standards of dealing with property. So I just want to give you some considerations about the impact of this. There is no charity in the state of Georgia that does not want to be accountable to their donors. In fact, the Georgia Code sets out the duty of care, duty of loyalty, and duty of obedience, and those actually govern boards of directors of charities in their prudent management of the funds that are donated to them. I would also point out that Georgia does not have a problem with these standards at this point. There's been no cases brought. In fact, to the contrary, I'll give you an example. The Community Foundation for Greater Atlanta, which is now a $1 billion collection of donor advised funds, had a fund from the 1950s. It was slated to benefit a specific disease that literally no longer exists. And for many, many years, about 30 years, that fund sat dormant because it could not be used. And they did the proper procedures, went to the AG's office, went to court, and they got it amended to use for health purposes. It still has to be used for the purposes that the donor intended, just not for that particular disease that it would never be used, right? And so they got it amended in the proper fashion, and now that is it's actually helping a lot of people with health problems across Atlanta. So we already follow those provisions. We require charities to manage funds consistent with their charitable purposes, subject to any gift restrictions imposed by donor intent. This is all laid out in 4415, sections 3 through 6. Georgia law authorizes charities to seek court approval to lift donor restrictions. Now, with the new MEPFA regulations, they can go to the attorneys general, as I said, and keep the courts out of that, and a lot of capricious lawsuits. There's already provisions in the law for standards of conduct related to the management of charitable funds. That's in 4415.3. There's already a low threshold for unilateral decisions. That's not any decision. That's a unilateral decision by the board to the modification of assets valued at $100,000 or higher. And it's also important to note here that most endowments aren't $25,000. You don't create an endowment of $25,000. You might have a collection of funds that include a $10,000 gift, a $25,000 gift, a $1 million gift, right? So we already have, it would open the gates for anyone, descendants, the advisors, as you well noted, anyone throughout time to open capricious lawsuits related to a $25,000 gift. So the threshold is already low, $100,000, and we want to lower that and broaden the scope of who can bring court action. We also want to broaden the scope, or rather restrict the scope of remedy for the charity. So charities would now have to go to the court. They could not go to the AG and have this mediated for these issues. And I would just want to give you a couple of considerations and examples of the impact of this type of restrictiveness. We have cases that Philanthropy Roundtable also brings up, but some of these are in the written agreements of donors, and this is the problem with these written agreements. Some are short-term issues. So there is a case of the Buck Trust in Marion County, California, and this person gave a stock valued at $7 million. Well, within a matter of years, that increased to $400 million, as stocks sometimes do. It was limited in the trust agreement or in the endowment agreement to poor and needy people in Marion County. The use of that. Marion County is one of the highest, wealthiest counties in California. And they sought relief from the court to expand that to the 5 counties surrounding. It essentially limited this charity of ever using these funds because there's not a lot of poor people in Marion County. There's $400 million, not $7 million, to deal with. So donor intent was actually affected by that. I'll give you another example. There was another charity in the Midwest that had a lot of art donated into a building. And in that trust agreement, it said the art would be donated to be utilized in the building that it was donated to. Well, the charity needed to move locations for a lot of different reasons, and they were sued from simply moving the art from one building to another. There's also language issues, language terms like income. Does that mean accounting income or does it mean capital gains income? It's not specified, for example. Or the word needy. How is that particularly defined? And are we limiting the powers of a board who is elected and is operating under the duty of care, loyalty, and obedience to the mission of that organization to exercise both the needs of the organization and the mission, but also donor intent? So there are a lot of issues, and it is extremely complex. And this particular provision further restricts, does not allow flexibility, but our code already allows a low threshold, flexibility for, quote, special circumstances, and we follow the majority of the recommendations already in this provision that they are talking about. So we're just restricting. We're not contemplating all of these eventualities, and it opens charities up, and it's generally the smaller charities, to capricious lawsuits. A lot of it administrative expenses, tracking $25,000, the returns on those, itemizing what they're particularly using $25,000 from 1932 on. And it's untenable. It really goes against a lot of donor intent. If you thought about you're giving your money for the furtherance of that mission, you don't really want your money to be used for a lot of administrative costs. And so we would recommend that the committee hold this and study the impact, and we would be happy to participate in that. We would be happy to bring associations of philanthropic institutions from Georgia, Philanthropy Southeast, the Georgia Grantmakers Alliance, there is the Georgia Association of Planned Giving Council. There are a number of different entities that have not endorsed this from the state of Georgia. And in our conversations with them, they express it this way: this is a hammer in search of a nail. There is no problem in Georgia. There's no cases in Georgia.
All right, Representative Silcox.
So the thresholds that you mentioned, where are those?
They're already codified in, I believe it's 4415 Section 3.
Okay.
It's 100,000 and over. And so this would lower it to 25.
Okay.
Where is it? I'm sorry, I can't find it.
It's in their model legislation.
It's in the model legislation.
Whose model legislation? I'm sorry.
Philanthropy roundtables.
Philanthropy roundtables.
Right.
Okay.
This also, in line 50, talks about within 4 years in civil action, and that's sort of taking the AG out of it and bringing the courts into it, as I said, so increasing costs.
The code section you cited, does it deal with the charitable organization that does not spend the money the way the agreement was set out? Because I don't see that one in looking at that.
In 4415.3, or?
You're right, yeah.
When you
I
say
see the
deals with
management
them.
of money that it talks about, but I don't see where, if they mismanage the money, what happens.
Well, and that's where we get into these language ones. What do you mean by mismanage? Invest the money in a certain manner, or
Not
use
follow
returns?
the agreement. They violate the terms of the agreement. is
Right.
what I'm
There
talking
are remedies for donors around that. They can bring a complaint to the AG, and the AG can look into it.
And you see
Yeah.
this bill as conflicting with that?
I'm saying that we already have strong and strenuous provisions for remedies for donors, as well as provisions for charities to change these, and it's unneeded.
Okay. Representative Kelly.
I just still want to get clarity on where we've lowered the threshold. If you could point to a line item, a line number that says where we lowered it.
I don't see it in the bill readily.
That's good news.
Mm-hmm.
Vice Chair Reeves.
Charitable trusts, those are situations that sort of fall between the cracks legally. Those are not contract actions where you have two parties to a contract, right?
That's correct.
Okay.
Yes.
And as I look at this bill, this is a contract bill that says that a contract between a donor and a charitable institution, it's going to be enforceable in Georgia. So that would sort of, send this in a different category than a charitable
It would, an
trust where there's
entire,
a failure.
different category. And also, I might add, 501c4s cannot take a charitable deduction. You can't take a charitable deduction for your gift to a C4. It includes a lot of civic organizations. So if you think about a lot of entities that support quasi-governmental, like Friends of the Library, Friends of X Park, et cetera, that's what affect them as well.
Well, the way we do it, you mentioned a community foundation. The way we do it in my area, a lot of those 501c4s, they set up a donor advised fund at
Sure.
the community foundation,
Right.
which is 501c3, and they say for our charitable initiatives, give to that donor advised fund.
Right.
So that's one way, practically, why how the 501c4 like Rotary, Kiwanis can do charitable
right.
giving, right?
Yes.
Thanks.
All right, I see no other questions. Thank you. Next up would be Dana Kraft.
Good afternoon. My name is Dana Kraft. I'm Executive Director of Feeding Georgia, which is 7 regional Feeding America food banks that operate in almost every county in the state. I'm speaking to you as an individual who also has extensive experience with philanthropic trusts. I've been Vice President of Programs at the Council on Foundations in Washington, D.C., which is at the time 1,700 community foundations and private foundations. I've worked at the Philanthropy Southeast when it was the Southeastern Council of Foundations. I also served 7 years as a trust officer in the SunTrust, now Truist Endowment and Foundation Group, where I served as trustee for charitable trust or trusted advisor to nonprofits who had their endowments. And I believe that the current Uniform Prudent Financial Institution Management Act and the section of the Georgia Code that covers trust and wills and estates is adequate to protect donor intent. It requires people who feel that that they have a cause of action to go to the Attorney General so that there's some conformity sort of to what standard that they are going to apply. I actually tried to modify a trust when I was at SunTrust that was done in 1945, and the Attorney General's office wouldn't let me do that. So I can tell you they really believe in donor intent. And I will say that every nonprofit in the state believes in it because they couldn't raise money if the donors didn't trust them. And I believe that this model legislation, like a lot of model legislation that comes out of national organizations, doesn't take into account what's already working well in a state like Georgia and could bring unintended consequences. And I'll give you an example with the ability of descendants of a donor to bring an action around donor intent. Because there's an interpretation in here. I'm not a lawyer, but I will say my understanding when I went to trust school was what is written is what is the law, right? And so in the food bank sector, we work with a lot of religious organizations who do not want to operate government programs. They don't believe in them. They have a lot of donors who believe the same thing. And so our food bank network operates in this really interesting nexus of some of their nonprofit partners are operating government programs like after-school meal programs for children that are federally reimbursed from USDA, and some of them will only do backpacks with charitable food on the weekends, right? So imagine a living donor who makes an endowment to a food bank to end childhood hunger in their community. And at that time, the organization, the food bank, is only doing charitable weekend backpacks. And after a decade, that donor is gone and has passed on. And the food bank decides that the best way to end childhood hunger in their community is to operate the summer meal program with USDA, which is a government program that reimburses for the meals, but there are other expenses that are associated with delivering the meals. And the daughter of the donor says, "Mom hated federal government spending. Mom would have never supported this program for government spending, and I'm going to file a lawsuit and see if I can get a judge to agree with me." Whereas now, they could still complain, but they'd need to go to the Attorney General, who would have an opportunity, and they have lawyers there in their charitable division, who would look at the endowment agreement and make a determination about whether or not they have a cause of action. And if they have a cause of action, the Attorney General brings it. So I just don't feel it's necessary, and I think it could send a signal to donors that are considering giving to organizations in the state of Georgia that we have a problem when we don't. You notice all of the examples that they've been bringing up are from other states. They're not from Georgia states. So I'm happy to take questions.
All right. Vice Chair Reed.
When Truist acquired SunTrust, what's the current minimum threshold of a trust or estate that Truist will manage now?
I don't know.
It's pretty high now, isn't it?
I don't know.
Okay.
I left. I went to Washington D.C. before that acquisition happened.
And this bill goes into effect mid-2024, and it pertains to transactions after that date. Don't you think this bill will help bring more money into Georgia from national donors rather than taking money out of the equation?
I don't think so. I think that it will make nonprofits cautious about accepting any money. And I think it will make nonprofits question whether or not they are able to, I agree with Representative Oliver. It's going to lawyer up a lot of these endowment agreements to make sure that there's a secondary beneficiary and things like that. But I do think that it will make nonprofits more cautious going forward. And I think that the unintended consequences are not now with living donors who are clear and working with the nonprofits. I think the uncertainty is what's going to happen in a decade or two when the descendants of a donor are looking at how a nonprofit is operating and trying to decide whether or not what they believed their parent intent was is I think where a problem is.
Well, would when you were trying to change that before, this legislation would have helped you, wouldn't it?
No, I don't think so. I think because the bank as trustee was sort of bringing the action, so I don't know that it would have helped. But it was a loan fund for students set up after World War II, and the interest rate on the loan fund was higher than the federally subsidized student loans at the time. We couldn't take anybody who would give it. So we wanted to turn it into a scholarship fund. And because the money from the endowment was returning more than the 5% that the students were paying back, and the Attorney General said, no, I believe that the donor intended to create a loan obligation that needed to be paid back, and they wouldn't let us change it. So, but that was,
Okay, thank you. That's all the questions.
Thank you.
Mr. Chairman, you want to finish up?
Like just a quick close, please, Mr. Chairman. These speakers actually argued for my bill. I mean, they are showing the current law did not give them the adequate remedy because you have to get the Attorney General to file an action for you. And you can only do that if it's over $100,000. First of all, there is no dinkering at all with any thresholds in this bill. You read every word, you won't see the word 25,000 or 100,000 or anything. This is independent of those uniform laws. It is creating an additive remedy, not an exclusive remedy. Still go get your Attorney General if you want him to do it. My message to these people is don't take money for a specific purpose if you're not willing to spend it for that purpose. Say, hey, we're the food bank, we're going to spend it for whatever kind of food project we want, but we only accept unrestricted funds. But if you're going to accept a donation under a written agreement now where you agree to use it for the purpose, well, then do it. And this gives these organizations remedies to go to court, and it gives equitable powers to the court to amend things in the future as the circumstances have changed to best enforce the wishes and intentions of the donor. So it is not a weapon to be used against them. It is a tool to encourage more contributions if the donor is willing to take them with the restrictions. And I would appreciate your favorable consideration. Last comment, I think you hit it, Representative Reeves. The effective date is July 1st, 24. And on line 69, it only applies to endowment agreements after that date. So anything happened in the 30s, this isn't given a remedy for somebody to go back and enforce an agreement before this law becomes effective this summer. So thank you for your consideration.
All right, thank you. Any discussion by the committee? Do I hear a motion? All right, got moved in a second. Any further discussion? No amendments, I take it? All those in favor say aye. Any opposed? All right, bill passes. Thank you.
Representative Kelly, I think you said you would be willing to carry this. Is that my right? Okay. All right. Be my honor. Thank you very much, Mr. Chairman.
Yes, sir. 64. Sorry you had to be the last one.
Well, I'll tell you, Mr. Chairman, for as long as I serve in this General Assembly, I'll always remember that I was sitting in this meeting, sitting in that chair over there when my son texted me and told me that my 5th granddaughter was born just about 15 minutes ago.
Oh.
So I'm very happy.
Wow.
So, good news.
Yes, sir.
Good news. Healthy little girl. Senate Bill 64, as I presented this morning, is a bill that moves an obstacle out of the way of 18-year-old adults who had been adopted at birth or as children, gives them the opportunity to go and get their original birth certificate when they turn 18 years old so they can be treated the same as everybody else. Because today in the state of Georgia, we can go and do that, any of us who are not adopted. But if we are an adopted child who wants to know our history, wants to know where we came from, then it's a process, a court process. And what this legislation does simply is move that obstacle out of the way and provides those adoptees with the same rights that all of us have. And I'm going to keep it extremely brief, and I'm willing to answer any questions. And I know there are others here signed up to speak to the bill.
Well, I don't show that on my list that I have, so they're not.
If they need to.
Oh, from subcommittee, yeah.
Yes, sir.
Vice Chair Reeves was to give a report on what we did, so do you know where he went? Yeah, we'll go ahead.
At the
Representative
appropriate
Silcox.
time, Mr. Chairman, I'd make a motion to pass.
All right, well, there's no other questions by the committee? Now would be a good time.
I so move.
All right, I got a motion and a second. All those in favor say aye.
Aye.
Any opposed? Bill
Thank you,
passes.
Mr. Chairman. I
Yes, sir.
appreciate that a lot.
And we are adjourned. Thank you.
There's some advantages to being last.